Good afternoon, everyone here gathered here in Washington, D.C. in Venable's offices, and good morning to those of you on the West Coast and anywhere else you may be across the country. Welcome to our program today entitled UBIT, What Your Nonprofit Needs to Know About Sponsorships, Advertising, Royalties, and Cause Marketing. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm, and this program is part of the monthly series that we do in person here in D.C. and live via webinar for those who can't join us in person on a wide variety of nonprofit legal topics. Today's event actually marks our 6-year anniversary of these events. And fittingly, we actually have a record crowd, a total of about close to 600 people who registered for today's program. So that's very gratifying that 6 years later we've gone from probably 75 people or so to start to now close to 600. And we're very glad that you are part of today's program, and I know a lot of you are repeat attendees. For those of you from the Trade and Professional Association community, these programs are eligible for continuing Association Executive CAE credit for continuing education. Preview of our upcoming scheduled programs on May 19th. Fittingly, for a very popular election year, we have our program entitled Election Year Activity, How Your Nonprofit Can Be Legally Active in the Political World. We have the two co-chairs of Venable's political law practice who work very closely with many of our nonprofit clients in this area. It's going to be a terrific program and one I hope you can join us for. And then on June 21st, our program is entitled Investigating Employee Misconduct in the Nonprofit Workplace. One of my colleagues from our labor and employment group who works regularly with our nonprofit clients will be teaming up with someone on the in-house side, and it's going to be a very interesting and very important dynamic program that I know you will enjoy and get a lot out of if you can be able to join us for that program on June 21st. In terms of today's program, those of you in the room have a handout booklet in front of you that has printed copies of the PowerPoint slides, along with full bios of our speakers and some ancillary handout materials, namely some articles that we at Venable have written on a number of the issues that relate to today's topic. Some of them are going to be very helpful resources for you, especially as we get into some of the complex nuances of things like the corporate sponsorship rules and the rules for royalties and whatnot. The articles, I think, do a good job of laying out a lot of the details in a very easy to understand manner, so I'd encourage you to take a look at them afterward. Those of you on the webinar have a copy of the PowerPoint slides that was linked to your confirmation email, and then tomorrow everyone will receive an email that contains all of these materials plus a link to a recording of today's program. We record all of these programs and host them on our nonprofit YouTube channel. Links to that YouTube channel along with all of our other online resources can be found on the last slide of today's PowerPoint presentation. In terms of questions, it's going to be challenging with such a large group in person and on the phone, but we do encourage you to ask questions throughout, although please don't get mad at me if I cut off questions or have to cut you off, have to move things along. We do have a lot of material we're going to cover, but I know we all know, our speakers and myself, that it's a very complex area. It's an area that I've been living and breathing for the last 20 years or so, and it's a confusing area. And I know that while some of you are kind of seasoned nonprofit executives that have been dealing with these issues for many years, many of you are relatively new to the issues as well, and so it's going to be a tough balancing act. But do ask questions throughout. Those of you in the room, raise your hands sorry, and wait for the microphone to come to you so everyone on the phone can hear you. And for those of you in the webinar, pose your questions to me using the chat feature on the webinar software. Now, last but not least, our speakers today. To my far right is Lakshmi Ramani. Lakshmi is Chief Legal Officer for the National Association for the Education of Young Children. We've had the opportunity to work, both Lisa, myself, and others at our firm with Lakshmi for a number of years, both at NAEYC and previously at her prior job where she served as Senior Attorney for Corporate Services at the Nature Conservancy. So we've worked with Lakshmi for many years. She is a pro in this area. She not only understands the law and the rules and whatnot in the whole unrelated business income tax area, but really has a tremendous handle both from the Nature Conservancy and NAEYC on how this all plays out from a very practical perspective in the nonprofit context. And I know you're going to get a lot from her remarks here today. And then to my immediate right is Lisa Hicks. Lisa is a partner in Venable's nonprofit practice. someone I've had the privilege of working with now for quite a number of years. Lisa's a key leader in our nonprofit practice, deals with all of these nonprofit tax issues and many other nonprofit legal issues on a very broad scale for many, many, many nonprofits each year. She is an expert in this area as well, and I'm really pleased that both Lisa and Lakshmi could be here with us today. You can find their full bios in the handout materials. With that, I'm going to turn it over to Lisa to get us started. Lisa?
All right. Well, thank you, everyone. So, this is kind of PowerPoint 101. I have to start off by giving you a roadmap of what we'll be doing. So we'll be talking about, at a high level, what is unrelated business income? What are some, I'm getting a little bit of feedback, sorry for that. What are some of the kind of tricks of the trade? How do you recognize it and how do you deal with it? We'll also, that's a kind of a nice platform and segue into what are some of the exclusions from UBIT. Now some of those are set forth in the statute. We are going to particularly drill down on 3 of them. Qualified sponsorships, licensing income, and really that is also related to royalty income. What is a passive royalty license and what's a qualified sponsorship? And we'll also talk about cause-related marketing, which you all know often always builds upon these concepts but is also more tightly regulated, so we'll talk about what that means and how it's regulated. All right. So for the people out there who really like the code, this is like the origin story, right? This is where you get unrelated business income. I'm not going to read the whole thing to you. I'm going to talk about what it means. So as you know, there is typically a 3-part test for what's unrelated. Now let me stop before I even start and say a couple of things. One is that many clients come to us with fear of UBIT, fear. We don't want to generate it. What will it mean for our taxes and status? I am a believer that there are many good reasons because the income is important to the organization, that doing activities which involve UBIT is okay. And typically, this is the question I always get, the rule of thumb is if you get to a point where you're around 15 to 20% of your activities or your revenue are UBIT, i.e. they show up on that Form 990T, then that's when you have to start thinking about exemption being an issue. And we can have another presentation on this. It's probably up on our YouTube website. That's when you start thinking about creating subsidiaries, et cetera. But for today, we'll go ahead and talk about some of the tests. But the thing I want to say from the beginning is that UBIT is not necessarily bad.
And I'll also add that you see people's reactions across the board. Some say, no big deal, I'm going to pay tax on it, I know I'm fine, and some are like terrified of it.
Right.
I've had other associations and organizations call me and ask me about it, and I'd say, particularly when it's something that's straightforward, advertising, you're going to pay tax on it. But when you start to get into having a lot of UBIT reported related to marketing and cause marketing, I'd really sit back and think through how you want to approach that, because the IRS, they get confused very easily. And if they start to see that you have a lot of UBIT on your 990T relating to marketing, they're going to wonder, well, unrelated, private benefit, what's going on? And so that's just something that you've got to look at yourself and make that determination for your own organization depending on the situation.
And just a couple preliminary points on unrelated business income tax generally. First off, this section of the tax code was enacted by Congress back in 1950, and it was enacted largely out of concern that nonprofit tax-exempt organizations, and as we know here, these unrelated business income rules apply to tax-exempt entities, not just an entity that's a nonprofit corporation, but it has to be federally tax-exempt. And there was concern that tax-exempt entities were engaging in for-profit businesses in a competitive manner that was unfair to the taxable for-profit businesses against whom they were competing. Congress did consider banning activities, commercial business activities that were unrelated to the mission of a tax-exempt organization, but instead they settled on the approach that is now codified in the unrelated business income section of the tax code, which basically says you can engage in these activities that may have nothing to do with your tax-exempt mission or purpose at all. That's fine. However, if you do so, you're going to pay tax on the net income, gross income minus directly connected expenses that you incur to generate that income, in the same manner that for-profit taxable businesses are taxed. And you cannot earn too much unrelated business income. If you earn too much unrelated business income, like Lisa said, you could jeopardize your tax-exempt status, although there are very good alternatives for how to deal with that problem if you get to it, to make it not a problem and turn it into a good solution. The other point I want to make at the outset is that, like Lisa and Lakshmi both said, it's important to really understand this area of the law, and not just you, the folks who are here in the room and on the phone, but all of your colleagues back at your organizations, especially those who are on the front lines of generating revenue for your organization. It's really important to understand these rules so that you don't let the tax laws be the tail that wags the dog, but instead you really understand the stuff so you don't get scared of it, but instead you use it to your advantage. A lot of what we're going to talk about today are what are actually exceptions to unrelated business income. And the more that you can craft these buckets of revenue that your organization earns in a manner that can fit into these exceptions, the more tax-free income you're going to be able to earn. Obviously, more tax-free income, more you can devote to your mission and your purposes and whatnot, which is great. But even if you find that you're in a situation where you can generate some really significant income, but you can't find a way to either make it related income or to put it into one of these exemption buckets, then don't be afraid of earning some unrelated business income. It's better to earn 60 cents on the dollar than 0 cents on the dollar. And even if you start to earn a lot of it, there are mechanisms like forming a wholly owned taxable subsidiary that you can utilize to still be able to earn that money on an unlimited basis without jeopardizing the organization's tax-exempt status. But you don't get to any of this if you approach it with fear. And like Lakshmi said, so many of our clients, they think, we can't earn unrelated business income. It's look bad. We don't want to pay tax. We're going to jeopardize our exempt status. But it's so far from the truth. But it all starts with knowledge, and that's what we're going to try to help you with today.
All right. So what is UBIT? So UBIT is, you all probably are familiar with it. It's the classic three-part test. I'll go through each of the parts. But number one, is it a trade or business? Number two, is it regularly carried on? And number three, is it not substantially related to your exempt purpose? Those are my next three slides. We'll walk through it. Is it a trade or business? What are they getting here? I like to think of this as sort of, does it quack like a duck? Does it walk like a duck, right? I think that the IRS is what they're typically getting to here is this the kind of activity that is typically engaged in by for-profit companies? It's only one of the factors, but in revenue rulings related to trade or business, what the IRS is often looking at is, would it be unfair to effectively subsidize a tax-exempt organization operating in this sphere because everybody else is paying taxes? And so that's one of the factors they look at is, what does the marketplace look like? And frankly, it's one of the things that I recommend that you do when you're considering whether or not this is a taxable activity is to look at what is the profile of the organization that's doing it. Now, one of the things that the IRS looks at is a profit motive. But that said, we like to promote entrepreneurial spirit. Not all business ventures are profitable. So it is certainly not the case that you have to be profitable in order for it to be UBIT. But the IRS will look as to whether does this activity primarily advance a mission of the tax-exempt organization, or really is it engaged in to generate income and therefore there is a profit motive? Now again, the IRS in this Mueller case is kind of a funny example, but it's the one that everybody remembers, where a law school opened a pasta company. Well, clearly they're not related. There are any number of companies which sell pasta, so that was kind of an easy slam dunk. A lot of times where it's, and we'll talk about it going forward, it's a little bit closer line. But I think one of the best things that you can do here is to really look at what does the marketplace look like. And again, the IRS is mostly concerned with, does exemption provide an unfair advantage to you here? Now let me say, all three factors must be met, right? So regularly carried on. This is actually an area in which many organizations can get out because they're engaging in, say, a one-off activity. And what the IRS will really do is look at how frequently you're engaging in your activity and compare it to other companies which are engaging into this activity on a commercial basis. So as an example, I was reading this morning, one of the examples was, it's interesting how a tax-exempt organization would get involved in this, but the tax-exempt organization was starting horse racing. And they were saying, okay, but we only do horse racing between, I don't know when you do horse races, but 4 months a year. And the IRS came back and said, yes, that's the common commercial model. You don't do horse racing during the winter. So just because it's a limited duration doesn't mean that it's not for the exact same period as other commercial entities do it for. The contrast example that the IRS gave that I read this morning was an organization which for only 2 weeks a year sells sandwiches related to one of their functions and also to members of the public. There the IRS said, well, that's really intermittent. And that's the key. Is this intermittent or is it regular? And regular does not mean that, one of the examples I have here is the NCAA case versus the Veterans of Foreign Wars. If, for example, you're selling holiday cards and you do it every holiday, even though it's for a limited duration, the IRS will most likely say, yes, but that's when we would expect you to do it, and you're doing it on an annual basis. So kind of bottom line, and frankly, when we're looking at UBIT analysis, we always want the documents to be clear, and we're always really looking at how will the IRS look at this should they ever come and look. I think that regularly carried on is kind of one of those soft facts. You can characterize it in your favor or not. But I think it's difficult unless it's a truly one-off activity, such as the 2 weeks that they're going to sell sandwiches, to get out on the basis of regularly carried on. So my word of caution there is that the IRS will find a pattern if you're doing it year after year after year.
Yeah, especially if for-profit commercial businesses are doing it in that same manner, in that same frequency. That's probably the key factor.
Exactly.
But on the other end of the spectrum, the safe example is the activity. You're clearly engaging in some unrelated activity. It clearly is a trade or business that has a profit motive, but it only happens one time only.
Exactly.
That's the kind of example where you're probably going to be safe.
So one example of that would be we fairly regularly look at a client has sold a large asset, say a trade show. They've only done it once. That's kind of a classic example. They're not in the business of doing that, where you might have a one-off exception because it truly is not regularly carried on. All right, the third factor, not substantially related to exempt purpose. I think that this, we already talked, I always do this, I like to remind you of what the roadmap was. We talked about, are there other commercial entities engaging in this? How often do you engage in it? And then the third one I think is one of the most difficult ones, which is how is it related to your tax-exempt mission? Now, I repeat this because I get a call like this fairly frequently. Somebody calls and says, we've got an idea for this activity. Let's say it's, we're going to start a pizza company. Okay, I say, well, that's, Domino's is also in that business. So, and they say to me, yes, but we're going to use the income to support our tax-exempt mission. No. The need for income, while good, and again, we like to encourage entrepreneurs, the fact that you will use the income for a tax-exempt purpose is not the question. The question is, what is the activity itself, right? And also, there is a concept that the IRS applies, which is that you look at the activity itself, not at it doesn't change the character if it's within the context of a larger operation which is tax exempt. So an example, one that the IRS often uses, a tax exempt hospital has a pharmacy. That pharmacy serves members of the public. Question, is it related to their tax exempt mission? Well, the IRS has repeatedly said no in that circumstance, so unless there's some other intervening factors, which I'll talk about in a second. Even though it's part of the larger hospital operation, what you really have to do is look at the activities in a separate manner, right? So you're always looking at the different activity and income streams. Another thing that's really important is you're looking at it within the context of your organization. So what is relatedness within the context of a C3 organization is going to be really different than what is related within the context of a C6 organization. Some of that's going to be informed by your tax-exempt mission, by your application to the IRS, but be aware of what that means in different contexts. An example is, for example, certification. Certification is kind of a classic example that almost always it is not UBIT for C6 organizations. Almost always, again, another day we can talk about the exceptions to that, it is UBIT for a C3 organization. So that's an example where the same activity can be UBIT in one context and not UBIT in another.
And just to elaborate on that for a second, just so you know what we're getting at, it's a good illustration. Lisa's talking about professional certification programs. And the IRS said in a revenue ruling, probably about a decade or more ago, that in the case of professional certification programs, whereas in a 501c6 organization, which is designed to advance an industry or a profession, a professional certification program certainly fits within that exempt purposes if it helps to advance the profession. But that in a C3 organization, where the primary purpose has to be to benefit the general public, and that any benefit to individuals or companies or industries has to be secondary and incidental and no greater than necessary to carry out the public purpose, there the IRS has said in that ruling that professional certification program does not fit within the exempt purposes of a C3, and therefore if you earn certification program income, then that will be taxable unrelated business income. And that's actually caused many organizations in the last 10 plus years, we've worked with many of them to help either set up a separate 501c6 affiliate to run their certification program, or vice versa. And back to Lisa's point about you have to look at the underlying activity. It's the activity that generates the income. That's what you focus on for purposes of this related exemption. And Lisa's exactly right. In the case of, for another example, she gave the hospital example where the pharmacy is selling to members of the public as opposed to just providing pharmaceuticals to hospital patients. You know, another classic example that applies to probably most of you is the magazine or the journal of your nonprofit. That the overall magazine and journal clearly is in furtherance of your mission and purpose. But if you accept advertising income within that, then that advertising income gets carved out, and that is almost always, based on a U.S. Supreme Court decision from 20 plus years ago, taxable unrelated business income. And the last thing I wanted to point out here, and Lisa alluded to it, we're talking about, is it not substantially related to your organization's taxes and purposes? And obviously the C6, C3 issue comes into play, but also very much how you define your own specific exempt purposes is a critical factor. And how you define that, so you say, okay, what are our exempt purposes? Well, where do you look? You look to your Articles of Incorporation, to the Purposes Clause. You look to your bylaws, to the Purposes Clause. You look to your original tax exemption application, your IRS Form 1023 or 1024. You look at how you defined your purposes there. And then you look to the Form 990 that you file with the IRS each year. All of these things collectively essentially define what are your tax exempt purposes. And so from a planning perspective, if you think you're going to be engaging in activities that might stretch the purpose or definition of your purposes, the definition of your tax exempt mission or purpose, then you may want to make sure that all of those documents are amended to reflect a broader tax exempt mission or purpose. The broader that you can define your mission or purpose, the more you're going to be able to fit within that bucket and to be able to call it related. Because like Lisa said, if all three of the prongs of this test are met, trade or business, regularly carried on, and not substantially related, then you're going to be dealing with an unrelated business with unrelated business income. But if you can take out any one of those prongs, and the substantially related one is the one that we typically, most people focus on the most, then you might have a chance to argue that this is related income. And if it's related income, then you don't even have to worry about the rest of the stuff we're going to spend most of today talking about, which is all the exceptions. You know, all those exceptions apply when you can't get out of any one of these three prongs. And then you go to see, okay, there's a number of exceptions and exclusions. Can we fit ourselves into one of those?
Yeah. We're a little bit behind time, but you know, one other thing I'll mention on that before we go ahead is there is always, we talked about profit motive. Here I've got Rev Rule 81-138, which is where a Chamber of Commerce leased a building at below market rate. There is a huge class of activities which tax-exempt organizations which engage in, which really there is no profit motive. For example, they're providing low-income housing, or they're providing, it's a pharmacy, but they're providing drugs at no cost or low cost. There are always ways for an organization to participate in what otherwise would look like a commercial activity, but because there's essentially no profit motive and they're serving a different class of low income, by making the services at that cost, that it will fail the profit motive and it will be seen as substantially related. So always important to keep that in mind. So just as a reminder, you know, of course, Jeff already mentioned it, it's a three-part test. You have to satisfy all three parts in order for it to be UBIT. There's some kind of classic slam dunks that are, classic UBIT, and which are not the subject of today, but I like to put them on the slides so that you can come back and look at them later. Things like advertising income, we're familiar with that. Rents from debt finance property, I recently had to deal with an issue related to this. A tricky and nuanced issue, but one that you should think through. Flow through profits from controlled entities. I have given whole presentations on this, but the general rule is 50% of value or control. If you have a for-profit subsidiary and you own 50% or more of the stock, or you are appointing or removing, or you have overlap of 50% or more of the nonprofit board, there can be control issues. I can't get into all of what that means now, but if you have that issue, come up afterwards and we can talk about it. There's also, and this is kind of a nice segue to the meat of our presentation here, there's specific exclusions from UBIT, and of course we're going to talk about a few of those today. But at a broad level, interest income, royalty income, which we'll talk about in depth, research income, certain of it. We'll talk about conference and trade show. This is a very expansive exclusion and one used by a lot of our clients. Qualified sponsorships, of course, and licensing, which often involves things like renting out your mailing list. So we'll talk about all of those, but those are kind of specifically identified exclusions.
And a lot of times when I look at the UBIT exclusions with either my colleagues or others in the association space, I'll say that you need to learn the rules. Don't try to make sense of them, because sometimes they don't make sense, and you don't know why those are the exclusions or why you have to meet those prongs. I think the UBIT ones, at least there's a flow. Right. But the qualified sponsorship ones, I mean, they're all over the map. So don't spend your time trying to figure out why on earth is
why
that,
2%?
why 2%, why regularly recurring periodical. Just there's no point in doing that. Just learn the rule and try to meet it, because then you'll be within the safe harbor.
Push down.
Okay. So the first UBIT exception we're going to talk about is qualified sponsorship payments, which often you'll hear about as 513I. And that's just the reference to the code. So UBIT is under 513, and I is the qualified sponsorship subsection. So the safe harbor is when you meet these certain, when you meet these certain rules, then you will be within the UBIT exclusion, and consequently you will not have to pay tax on what you're doing. And I tend to really like qualified sponsorships on a different matter when you're looking at corporate marketing promotions as a whole, which isn't the topic of this presentation, but when you're looking at that, a lot of times you're talking to a company that's coming to your organization. They're not looking at you saying, you're the marketing person, you're the philanthropy person, you're the grant person. They want to do something with you, and they're just going to throw whatever it is at you and expect you to understand how to figure out the structure. And I like corporate sponsorships because it allows a charity to work with a for-profit and give them a level of visibility that makes them happy without putting yourself at risk with UBIT or something else. So it's a nice model, and there's lots of materials out. I think even Jeff put some in your packet about that kind of thing. But so one of them is that you cannot give a substantial return benefit, which we talked about. But no, we talked about substantially related, sorry. Yes. But under the sponsorship rules, it's a 2%. So pretty easy math. So if they give you a certain amount of money and what you give them in exchange is more than 2%, you're basically kicked out of that sponsorship role, and you have to look at what you're doing from a different perspective. You have to analyze that at the basic level to figure out what kind of income is this and do I have to pay tax on it. That doesn't immediately mean you have to pay UBIT, but you have to step back and take a look and see what it is and what kind of income it is.
Yeah, and that's an important point that Lakshmi made, because we have clients all the time that get confused about that. They think if it doesn't meet the corporate sponsorship exception, then it must be taxable income. And that's not the case. It's got to think about it is that if it doesn't fit the exception, then you maybe can fit some of that or all of that into another exception, or you go back to the basic three-part UBIT test. Maybe you can take something that on the surface, or the way it's proposed to you, is not substantially related to your exempt purposes, but maybe you can turn it around, twist the facts around to make it substantially related to your exempt purposes. And there are lots of good examples and cases and rulings of how organizations have been able to do that. It's all going to be very fact-specific to your specific organizations. But just because it doesn't fit the sponsorship exception does not mean it's taxable automatically.
Exactly. It just means that you don't just meet these rules and you're good from a UBIT perspective. You basically then have to step back and sit with your tax person and say, okay, now what is this and how do we figure this out? Which sometimes takes more time, which if you have a company that you're talking to and they really want to move, that's going to slow things down if you don't just automatically meet the rules and then move forward. Speaking from the person who has to often structure these things and come back with, it's going to take some more time to figure this out, we didn't meet the rules. So now you can have user acknowledgement of the name or logo of the for-profit. So what I like about 513I is you can say sponsored by XYZ company, sponsored by XYZ company, where you're promoting your thing, whether it's a campaign, whether it's a trade show or convention. You're able to give that acknowledgement within the parameters of this 2%. It doesn't count. Although I was talking to Lisa and saying one situation I had was a little bit weird, but we had a website where we had little tiles where you could kind of recognize your corporate partners, if you will. And we started taking some of the tiles they decided to sell as ads. Well, how do you differentiate the ones you're selling as ads where you've now placed a value on them and the ones that you're just giving out as a benefit? Well, it gets complicated then. So can we really stay within the 2% or not if now we sell those as ad space? And then it gets a little bit hairy because the IRS is certainly going to want to push you out of the rule if possible.
I will say from my perspective, I rarely see the 2% rule apply. Usually what you're doing is analysis of each income stream.
And then you also have, we have the example here about the $5,000. So Hicks Corporation makes a $5,000 gift. Oh, did I miss one?
No, you just need to advance.
Oh, sorry.
No, you're fine.
I printed it because I can't see that far. All right. Sorry. So we've got an example of the 2% rule here. So Hicks Corporation makes a $5,000 gift, and you see when you start getting this $60 return benefit, you're in the safe harbor. But you can get out of it if you start giving them in excess of the 2%. And where I find this happen is if you have a campaign that you're running, a lot of times you're just giving them some visibility. There's not a lot of things that you're giving them that really count towards the 2%. Because I often see us fitting within 2%. I haven't seen a lot out of it. Yeah. But if you have a campaign where all of a sudden you have an event where you're selling tickets, or you have something where you've got tables or something else, then it starts to get a little bit more complicated. And you have to think through the 2%. And you can blow through that 2% really fast. It's not a very high threshold. So when you're looking at that, another way to think about it is with the acknowledgement, since you're allowed to basically say a sponsor is sponsored by, then the question is that within what I'm allowed to do, or is that advertising? Right. And that's also an interesting scenario because when you're simply saying that it's sponsored by, you're generally okay. Right. But sometimes companies want a little bit more than that. And they kind of want a charity to say a little bit more about them because they want that level of implied endorsement, if you will. So when you're just giving an acknowledgement, you've got the name of logo, the name or logo. You can give a description of the services or product lines as long as it's not qualitative or comparative. They're the best. Oh, I keep forgetting to clicker. No. Sorry. There we go. So they're wonderful. They're better. Things like that start to make you start to wonder, is that really advertising or is that an acknowledgement? Because if you're simply acknowledging them, you don't really need to explain whether they're better or what have you.
Right. So, one key concept is there qualitative language? I made up the example, of course, because my last name's Hicks, of Hicks Corporation. But if they were saying, we would like to thank Lisa Hicks, an attorney, well, that's a factual assertion. If they would like to thank Lisa Hicks, the best attorney, well, that's a qualitative difference.
Exactly. And you can give their contact information. A lot of times companies like a link to their web page, their home page, and we'll talk about it a little later, but if you link to an ordering page, then that's turning into a call to action, which we'll talk about in a minute. So you have to be mindful of where your links go. And a lot of times what I'll do in sponsorship agreements is I'll say exactly where that link goes to. Right. So that it's clear and they're not assuming that we're just going to send them straight to where you can purchase things. And some websites are tricky because almost every one of their pages is an ordering page.
Just to take a step back so everyone understands the concept here. These corporate sponsorship rules, which Congress actually wrote into the tax code in, I think, 1995, were designed to codify the concept that if a corporation, or could be an individual, I guess presumably, but usually a corporation gives money to a tax-exempt organization, any category tax-exempt organization. If you are merely acknowledging that contribution, then the idea is that that's not a taxable event. That's not taxable advertising. You're just acknowledging and thanking the sponsor. And it's one of the rare areas where the IRS has very, very detailed rules and examples to spell out what fits within that acknowledgement bucket and what falls outside it, where it's going to fall on the advertising side. And the rules were actually modeled after the Federal Communication Commission's rules for public broadcasting. If you think about the kind of acknowledgments that occur at the end of a public broadcasting show or at the beginning of it, that's really what these are designed to be modeled after. But the IRS went even further and came out with very detailed regulations that are extremely helpful. And all the stuff that Lakshmi and Lisa are talking about right now are pulled from those rules. We have some of it in the slides. The article that's in the back of the handout book has all of this in great detail. But the idea is that when you're doing things, not just saying thank you to the name of the company, you can do so much more. You know, non-qualitative descriptions of the types of products or services that the company offers, linking to their main page, providing contact information, address, emails, website, phone numbers. All of that is generally okay and within the scope of acknowledgement. But when you do some of these other things, you use qualitative language, you use endorsement-type language. We endorse them. We encourage you, our constituents, our members, to purchase this company's products or services. If you include price information, things like this are going to take it outside the realm of this exception. Doesn't automatically mean that it's taxable, but it probably makes it a little more likely that it's taxable advertising income, and it certainly takes it out of this bucket.
Yeah, and one that I often get questions on is the samples, because you're allowed to have them provide samples, but a lot of organizations, that just seems so off.
Right.
Because you're not supposed to talk about how good they are, how bad they are. You're not supposed to do all these things, but they can hand out their products. So that seems a little bit like an oddball, but it is allowed.
Right.
And then we have a couple of examples here with a name and logo on functional items. So the use of a sponsor's name and logo on advertisements for events, event programs, cups used as events, and helmets and jerseys on players. I mean, that's generally allowed.
All of that's allowed and comes right out of the regulation.
Yep. Yeah. Naming events, Coca-Cola Young Scholars Program. A lot of times companies love having things named after them, and this is a nice way of naming something that isn't like a building or something permanent. So you could do that with a donor.
Right.
And then you've got a list of sponsor names on website, including hyperlinks to their site. So a lot of times you'll see like a donor roll almost, but you have a list of sponsors. But I also allows you to use their logo. If you want to put their logo on there, you can do that too, and that's why I is nice, because you can still have some of that philanthropic feel, but you can do it a lot more than for a pure donor.
Right.
Yeah, you can even use a slogan. If it's an established slogan of the sponsor, you're allowed to include that as well, even if it has some otherwise descriptive language or whatnot. It's okay as long as it's an established slogan. So you can fit a lot into what Lakshmi refers to as I.
Yeah,
13I, otherwise known as the corporate sponsorship exception. You can fit a lot in there. You can give a lot to the corporations, and that's what Lakshmi was saying earlier, that, if possible, try to get your corporate partner sponsors, the corporations who want to support your organization, try to get as much of it into the 513I bucket, because if you can, it makes it easier, to just say this is all tax-free income. But if you can't, and it's just the sponsor is insisting on something else and they're willing to really pay for it, don't be dumb. Don't turn away the money. Just either find another way to maybe take it and put some of it maybe into a royalty bucket that we're going to talk about, or it's not the end of the world to pay some tax.
Right.
Not the worst thing in the world at all. Yeah. Question in the back. Just wait for the microphone if you could. There it is.
Thanks as usual for a great presentation. Does one taint the other? So if you have a lot of stuff in bucket I, but then you also end up with something which becomes advertising, does the IRS try to smoosh them together?
It's a great question, and the short answer is no, it doesn't taint, but you do have to be cognizant of how you do it. So for instance, we're going to talk about this, about the fact that a lot of these complex arrangements, relationships, partnerships, not in the legal sense of the word, of course, between a for-profit corporation and a nonprofit, they take multifaceted, multidimensional shape. And so you may have some corporate sponsorships where you're acknowledging the corporation at certain events on your website, things like that. They may be having a booth at your trade show or your convention. They may be advertising in your magazine. They may be slapping your name and logo on products that they sell. You give them the right to do that. And so in just that one example, you have qualified corporate sponsorship income, tax exempt, it's an exception. You have qualified convention and trade show revenue for the booth at the trade show, tax exempt under that exception. You have potentially tax exempt royalty income for the licensing of your name and logo on their products or services, tax exempt royalty, another exception. And then maybe you have taxable advertising income, which is obviously going to be taxable. What you want to do is avoid the temptation to try to push all of the money into the 3 tax-exempt buckets and only keep a tiny fraction in the taxable bucket. The IRS says you have to allocate based on fair market value. And so if you otherwise sell your ads for certain rates, you need to follow that same process in valuing how you divide up the money into those different buckets. Same things with booths at your trade shows and things like that. And if you do that, then we recommend a single agreement, but with different subsections that divides it up like that. It's a great way, and it's what Lisa and I want if we're coming to defend you in IRS audits, and we've defended many tax-exempt organizations in IRS audits. We want to be able to say, look, IRS, here's these 15 big deals that our client has with different companies, and here's the agreement that lays it all out. Here's the different benefits they're getting, here's the buckets that the money's allocated to, and then you look at the 990 and you see everything flows through accordingly. That is gold for us in terms of defending you in an IRS examination. Unfortunately, most organizations don't fall into that bucket, into that situation, and it's much harder to do.
Yeah, and I'd also say that a lot of times when I've seen these things don't come to you so clean, where the company's asking for something and boom, it just fits into qualified sponsorship. I won't keep calling it I, but it doesn't always cleanly fit, and sometimes you really do have to explain to the company, we have to classify this in different ways in the agreement, because we have certain things we have to show and we have to explain, because sometimes they're just expecting something very simple. And it's not that it's complicated or simple, but you have to do it properly so that you can give them what you want, and you can, as Jeff said, value things appropriately, because you can't just make it fit just to make it simple. And so what we do is we do break it out like that. And it also helps finance, because when they're preparing the 990s and they're looking at those agreements, and it's very clear, this is the qualified sponsorship, this is trade show, convention, what have you, it makes it a lot easier for them to prepare the returns.
But what Lakshmi said is so true, and we all see it. When it comes to you, when the proposed deal comes to you from the corporation, it's not broken out into these buckets. It's not even anywhere close. And frankly, your development people, your marketing people, they don't break it out into these buckets. And a lot of times they bring the whole deal to you, right, Lakshmi, after it's all negotiated, and then you're trying to basically break it all back down, which is why what I was alluding to earlier when I said get everyone on the same page, get them educated. You guys got to go back and educate your colleagues about this stuff now, so that at the outset, your frontline people who are cultivating those relationships and bringing in that money can help structure things that way at the outset. We're going to need to blow through that. I think move on to royalties. One important thing to keep in mind, though, by its own terms, the corporate sponsorship exception does not apply to sponsorships in periodicals, like magazines, journals, newsletters, any regularly printed material, whether it's in print or electronic form. And it also does not apply to conventions or trade shows, qualified conventions or trade shows, but there's that other exception that applies to most of that income.
Okay, so I'll pick up at royalties, but let me just say, these slides, if I may say so myself, are really good, and outline you through all of the steps of the analysis, and outline all of again, as Jeff said, the IRS has been very detailed in this respect. So often what you need to do is really go and read the regulations, and you find all that you need there. So let's talk about royalties. We talked about qualified sponsorships. Often it is the case that these agreements, packages, relationships don't come to you in nicely defined tax buckets. And so I'll give you an example. this often happens. A client will come to me and they'll say, you know, we want to partner with, I'm just going to make up an example, an insurance company to give member rates to our members on this insurance product. And we're going to help them market it, we're going to give them our mailing list, and we're just going to, you know, it's called a marketing services agreement. Stop. Most of the time in those situations, there is a great avenue to put a lot of the income into a royalty and licensing and separate it from your active marketing activities. So first I'll talk about what a royalty is, what is passive licensing is, and what it's differentiated from.
And I've used that model for affinity credit card agreements.
Exactly, exactly. So on the royalty, what is a royalty? A royalty is basically income that you receive when you've given a third party the right to use some kind of intangible property of your organization. What is this classically? Classically, this is your name, your mark, you know, your logo. It could even be things like your previously created copyrightable material. It could be things like patents. I mean, there's a wide range of things that can fit within this bucket. The classic case on this, of course, is Sierra Club. Primarily, and I already talked about this, the most classic examples are going to be things like name, mark, and mailing lists that they get the right to. Be careful with this when it says third-party products. One of kind of the more nuanced areas is if it's, I went to Smith College. If it's the Smith College credit card, well, clearly Smith College is not in the business of providing credit. That's a MasterCard credit card. There is a line of cases where organizations tried to say, okay, third party, we will license to you the right to create our journal. You give us back a fee, kind of as a tax avoidance scheme, frankly, so that they wouldn't have to pay taxes on the advertising. The IRS, there's a great IRS publication on this called Agency, really said in that circumstance, that really is your publication. You can't say that it's somebody else's. It really looks and feels like yours. It's different than the affinity credit card situation. And it's a situation I've seen come up a number of times. The big thing, though, is to differentiate between I give you what's called a passive royalty license. You can use my name, logo, etc. They're never, almost never, going to say that's enough. They're also going to ask for you to do things that are active. Things like, will you call our members, your members to promote this? Will you send out an announcement letter, etc. My kind of general rule of thumb is I'm comfortable with, say, a single announcement letter that we have a new member benefit or a new affinity partner. If you are instead, though, engaging in, if it's your chair or your ED, for example, regular promotion of this company and of this benefit, that starts to look not passive but very much like services. And the only thing that's important there, again, is not that you can't do it, but that you need to value those services and treat them as taxable income.
Yeah, just to make sure everyone's on the same page here, take a step back. So the idea behind the royalty exception is that if you are just letting someone else use your intellectual property and they're paying you for that right, that's a passive endeavor. You're not actively engaging in a trade or business. Therefore, you never rise to the level of an unrelated business activity to begin with. So anytime you're passively just letting someone else use your trademarks or your copyrights is usually what we're talking about, and you're doing nothing more except engaging in quality control, that's always going to be tax-free royalty income. Like Lisa said, though, oftentimes in these affinity deals and other arrangements with for-profit companies, they not only want to use your logo on their products, but they also want you to do some active promotion for them, active marketing services, because it carries a lot more credibility if it comes from you, not just from them. And so if you are in a situation like that, sure, you're still letting them use your name and logo. So there's still a royalty component. And one of the great things that came out of that Sierra Club case and other line of cases that occurred back then in the early 90s was this concept. The IRS was taking the position back then that if you engaged in any kind of active marketing or promotional services for these companies' products or services, that tainted the entire royalty stream, and all of it was going to be taxable unrelated business income. Because if you're getting paid to market someone else's for-profit company services, that's clearly an unrelated business activity, and that's going to generate taxable income. And they said it would taint the entire royalty component, and none of it would be tax-free. But what those cases said was that no, that's not true. The organizations fought back and said, no, we are licensing our name and logo and getting paid for it, but we're also providing some other services, marketing services, administrative services, if you're processing applications, processing claims, whatever the case may be. Sure, that part is an unrelated business activity, but that shouldn't taint the tax-free part. And so now, ever since then, we've operated under this world where you can have these companion income streams of tax-free royalties and taxable unrelated services income, usually from marketing type services. But like Lisa said, the key is valuation. Like I said earlier, don't put 99% of the money into the royalty bucket and 1% into the services bucket if you're really engaging in some meaningful, time-consuming, valuable services. You need to do a fair market allocation between the two. And your agreement, and this is really important, needs to reflect that. It needs to bifurcate the income stream within that agreement.
And when I've seen this happen, a couple things at least in-house have happened. It takes time to structure those as two agreements. It's not something that, you know, when you have an affinity marketing relationship or something where it's important to you to be able to promote it, because at the end of the day, it helps bring you more members, it helps your mission in some way, shape, or form. But the people putting that together have to basically create two contracts with two different values and figure out how to make them fit together and figure out how the finance folks can take that information and report it. So that's not like something, at least in my experience, that has been able to be put together quickly. The second thing is, when you are engaging in that promotion, also, you know, you can step back and try to figure out, are you promoting the for-profit or are you promoting yourself? And sometimes, depending on what the message is, it may or may not end up being a marketing service. You may be really promoting yourself, and it's very much of a case-by-case basis.
Yeah, that's what when I said earlier about you can sometimes change the facts around enough to make it a related activity. That's an example of it. You know, another example that comes from an IRS ruling, but I think it's a really helpful one, is a wildlife conservation organization that was selling desk accessories with their logo on it. Now, if you name your charity, name the purpose. If you're selling desk accessories, if you're selling hats and T-shirts, even if they have your logo on them, the precedent is very clear that that is not substantially related to your tax-exempt purposes. Even though it helps, you know, build brand awareness and, you know, gets your name out there more, that the sale of those types of products is going to generally be an unrelated business activity if you're doing it yourself. Of course, one option that you can probably guess is an option based on this discussion is the royalty option. You outsource it. You give a company the right to have your name and logo to put on those hats and T-shirts, and then they go out and sell them. That's okay, and then if you're not doing any marketing of that, 100% of that would be tax-free royalty income. But the ruling that I'm referring to is one where that Wildlife Conservation Society said, we're going to go beyond just putting our logo on these things. We're going to also put an image of an endangered species and then a piece of literature that describes that endangered species and what its situation is and what people can do to help protect that species. And there, the IRS concluded that that organization took what was otherwise an unrelated business activity and turned it into a related activity by furthering your mission or purpose. And that's really what Lakshmi was getting at in her example.
You see that with calendars, things like that too.
Perhaps we should skip over to the CCV. We have 3 minutes. Oh, we're going till 2. Okay, I'm sorry. I thought we were going till 1:30. Okay. Well, then we're good. Yeah. This whole time I've been going on a different time frame.
Yeah, we have a question there.
Yeah. I really did. I thought we were done.
So with regard to the services that are unrelated, does it matter if the services benefit a nonprofit rather than a for-profit? So if it's, I can't think of an example, but let's say it's a marketing kind of thing, which is not normally a nonprofit tax-exempt activity, but it was for another nonprofit. Would that change the analysis, or is it just it's not a? So
you're saying if part of what your nonprofit is getting paid to do is to market the services of another nonprofit, it's going to depend on the facts.
Yeah.
But certainly, if that other nonprofit is in your same field, and promoting them and their services promotes your own mission and purpose, then yeah, that is going to be a related activity. But just because the organization is a nonprofit tax-exempt entity, period, that's not going to be enough. And if your nonprofit is in the conservation space, right, and then but you're promoting the services of a nonprofit that's in Lakshmi's space of educating young children, even though they're both charities, they're both nonprofits, that's not going to be a related activity. So you have to look very specifically at the facts.
So if it doesn't further the mission,
Right.
Right.
Okay.
Yeah.
Right. Then it's unrelated.
Yeah.
Right.
No, we get into this issue. I think the IRS put out some guidance on this, but whenever we unfortunately have like a big a natural disaster, a man-made disaster, and a lot of organizations go out to help raise money for other nonprofits that are doing fundraising for victims of that tragedy. Technically, for a lot of these for most organizations, it's not. If you're not the American Red Cross or an organization like that, it's probably not within your mission or purposes. And so it's something to keep in mind. Although usually we're not talking about generating revenue for the organization, so it's not usually a tax issue for the nonprofit.
More of a fundraising regulation issue.
It can be that, and it can raise private benefit concerns. But anyway, let's move on. We're getting way too in the weeds.
Back to royalties. All right. So a couple of things. One is the IRS does allow you to do what's called quality control measures, and that is not seen as active services. So for example, if Macy was entering into, say, an affinity credit card arrangement, and Macy wanted the ability to review how the use of their name and logo, and perhaps review the quality and tenor of related marketing materials to make sure that it didn't reflect poorly upon Macy, that is permissible. The IRS will not say that that is active, but it really does have to be quality and brand management control. We already kind of talked about this, but there's often, the general rule is that the less you do, the more it looks like royalty income. So, some of the positive factors there is that the payment is really for an intangible right. I like to see, if you have an agreement and you are wanting some of the income to be passive royalty income, there needs to be a provision which says, in consideration for the use of your name and mark, for example, XYZ Corporation will pay this. In consideration of the services provided under this agreement, XYZ Corporation will pay that. In other words, and by the same token, I see this so often. You can't simply call something royalty or license and it fits into this exception. You really need to make sure that you aren't also doing some active services and put each of them in the appropriate bucket.
And one rule of thumb that I've used for the active promotion is also the call to action idea.
Right.
That if you have some kind of marketing relationship where, particularly in affinity marketing, use our card, use this credit card, sign up today, what have you, then that pretty much puts you right in the active bucket, even if you're just doing it one time, 2 times.
Right. So we outlined what a license is. We really already talked about this before, Jeff did. But, again, most likely what you're going to find is a dual purpose arrangement. Most likely a corporation's coming to you, and they both want to use your name and your mark, but they also want, for you to do some promotion. Again, the very best case scenario, the most conservative approach, is to do what's called a bifurcation of agreements, to have one agreement which relates to the royalty license and one agreement which relates to the services. That said, I would say, from what I'm seeing at least, the predominant model is a fused agreement. And in that circumstance, again, going back to what I suggested earlier, so long as you have clearly identified for use of the name and mark, it's this, for the services, and outline what those services are, both with respect to qualified sponsorship agreements and with respect to these types of agreements. The number one thing I see that's missing is, well, what are they getting? What are you doing? And the IRS, importantly, should you ever get audited, is not just going to look at the 4 corners of your agreement, they're also going to look at the reality of your relationship with this for-profit entity. So this is one circumstance in which I always tell the lawyers to speak to the marketing folks, because oftentimes it's just the nature of the business. There's been certain things that have been promised that don't necessarily reflect it in the agreement. You're in a much better position if it's all reflected in the agreement and handled. Really talked about this. I'm going to say it again. I said it before. If this is supposed to be a passive royalty license, don't call it a services agreement and don't call it a marketing agreement. It's one of the best pieces of advice I can give you.
Yeah, and some
that's what it is. It's called a licensing agreement.
Some nonprofits, in fact, even many nonprofits, are reluctant to, all the IRS rulings refer to a mailing list income these days, rental income. We're talking about emails these days for marketing purposes generally, and You know, a lot of organizations are unwilling to give out their members or their donors or their subscribers email addresses to others, but they'll say, hey, if you pay us XYZ, then we'll send them out to your folks. Just keep in mind that like I said earlier, don't let the tax laws be the tail that wags the dog. If donor privacy, member privacy of especially email address information is very important and sensitive, then do it that way, even though recognizing you may be engaging in some services, some marketing services on behalf of the for-profit company. You may have to pay some tax on that. But a very wise nonprofit tax lawyer, when I was first starting out practicing, told me in her mind one of the best ways to keep the IRS off your back and also to successfully survive an IRS audit on these unrelated business income tax issues is to pay a little tax. If you pay some tax, again, using some reasonable fair market value valuations for this stuff, it's much less likely that the IRS is going to come in and try to challenge it. You didn't allocate enough to the taxable side. But we see so many organizations that just claim zero unrelated business income. And when you look at you just have to go to someone's website usually, or you look at their publication, and you see there's no way that there is not some advertising income, some promotion of the for-profits products or services. We have a question from the webinar that I'll kind of change the question around, and it relates back to the corporate sponsorship stuff, but it's an important point that we failed to mention, and that is that the recipient tax-exempt organization's treatment of the income for corporate sponsorship purposes, or frankly for any of these purposes, is not at all tied to the donor's treatment of that payment for tax purposes. So the donor may be treating it as a charitable contribution if they're making their contribution to a C3 organization. Of course, if a corporation or an individual makes a donation to a C3 and gets something of value in return, unless it fits within a de minimis rule, they're going to have to, the amount of the deductibility, the charitable deductibility, is reduced by the value of what they get in return. Or they may be paying it out of some marketing or advertising account where they're taking a ordinary necessary business expense deduction for that payment, and they're treating it as a marketing expense. That doesn't matter from your perspective. It has no bearing whatsoever. Your treatment of it, your nonprofit's treatment for tax purposes, is based on everything we're talking about here, and it's completely disconnected from the other. But it's an important thing to keep in mind because a lot of people get confused about that.
So what I've seen happen is companies come and ask for an acknowledgement letter. I've seen that happen, and then we have to figure out,
How much of this is
and sometimes you can do that with the 513I. It's sometimes possible, but that's something that's happened to me in the past.
Yeah, when Lakshmi says acknowledgement letter, she means a letter that says, thank you for your donation, and here's the value of what you got in return, or you got zero in return. You are obligated to do that under certain circumstances if you're a C3 organization.
Mm-hmm. So we're going to jump to cause-related marketing. And cause-related marketing, just as a baseline, is when a charity is engaging in a marketing promotion with a for-profit that's usually public-facing. A lot of times you'll see this as either buy this and the charity gets either a percentage of sales or a certain amount of money per sale, but sometimes you'll also see it as a flat amount of money that is guaranteed to the charity for the promotion, and the company working with the charity puts that on their products. Sometimes what I've seen is a company wants to have a marketing relationship, and it turns out that we can set it up as a qualified sponsorship. But particularly when you have buy this and the company gets and the charity gets this, a lot of times, at least where I've worked, we've considered that to be a contingent payment, and consequently you can't use the qualified sponsorship rules under 513I for that purpose. Cause marketing is generally the income that you receive is royalty income, so it's not taxable. But you can have a lot of different things thrown in there. Every once in a while there will be an ad put in there. But again, are you promoting yourself or are you promoting the company? That's something that you have to figure out. And cause marketing is very heavily regulated. You've got how you classify your income from a tax perspective, but then about 38 states require registration for cause marketing. So when if you are a charity that fundraises, you probably already are doing your charitable solicitation registrations, and those are in about the same states. And so when you do that, many states require that you file information about your commercial co-venture relationship with the state as you do your charitable solicitation registration. And there's a handful of states that require pre-registration, post-registration by you and the company. And it all sounds very overwhelming. And what I'll say is I worked in this space for a very, very long time. And if you have a marketing person who understands how this works, it goes very, very smoothly. And the companies you're working with really appreciate that you understand the space and you can walk them through what to do, because they don't want to do things incorrectly when it comes to registrations and filings. At the same time, because there are registrations and filings, you want to make the return on investment goes down if you don't account for that when you're entering into these cross-marketing deals, because somebody's got to do the filing, somebody's got to keep track of the money. All of those things fall into play, so a lot of organizations have very high minimums when you enter into these CCV deals.
Yeah, and the regulation of commercial co-ventures at the state level it's in no way designed to prevent these deals from occurring. But like Lakshmi said, in some cases it involves registration, and that's actually very few. But in many other cases there are certain disclosures that have to be provided to the public in marketing materials and fundraising materials, things like that. There are sometimes some states require some provisions that have to go in the contract between the charity and the commercial co-venture, and a very small number I think you have to file the copies of the contract. But the requirements do vary. The sophisticated, big, Fortune 500 companies that work with charities all the time are generally familiar with this stuff. But even there, we find many are not, and many other smaller companies definitely are not. It can be daunting to them, but that's why Lakshmi said if you have someone on your staff who generally understands these rules and can explain them and can help shape the arrangement in a manner that works within these rules, and this is really important from a timing perspective. How many times have we gotten, and I see some of our colleagues in the room who work on these deals, how many times have we gotten the deal, well, we're launching next week, and this big new campaign, and someone said, oh, we might have some filing or something we have to do in a state. Every one of these states that regulates this stuff says you have to do the filing before you start the campaign. And you need to build in time to do this stuff. And so educating your folks early is going to be really important in that regard.
Exactly. And when
yeah, go ahead, Lakshmi, while she answers her question.
Thank you. In these cases, are you registering the specific partnership? Are you registering as a nonprofit who does cause marketing type partnerships?
So,
and just to follow up, and are you registering in the specific states in which you're going to have a presence, or nationally if you're a national organization?
So first, you're supposed to be registered to fundraise in the states that require a charitable solicitation registration. So that's your first thing that you should be doing if you're going to engage in this, because more and more companies that are getting savvier, they're asking for representations and warranties that you are complying with the charitable solicitation registration, because they don't want to get in trouble for you not doing that. I've seen that happen a bunch of times.
And if you're a C3 that's doing any kind of broad fundraising, CCV or otherwise, then you should be registered in those approximately 40 states that require charitable solicitation registration. That's an obligation on the charity to do the registration.
Exactly.
That's separate and apart. When you have something that fits the definition of a CCV, which is, might as well move to the next slide, then you have some states have registration obligations, generally on the for-profit company, I believe, where there's a registration requirement. But it does depend. And then, like I said, much more than the registration obligation, you have these obligations to follow certain rules in terms of how the campaign is carried out, marketing materials, contracts, things like that.
Exactly. So first, if you fundraise at all as a C3, you should be registered. You should be conducting your charitable solicitation registration. That should be taken care of, so it's done. Then when you enter into a CCV, which is a commercial co-venture, the definition in the statutes is always very, very broad. But, oops, wait, do I have the right? I think we have the statutes here. But New York is pretty standard. So any person who for profit is regularly and primarily engaged in trade or commerce, and it goes down to basically where they're telling people that the purchase of this product is going to benefit a charity. Now, so that means that usually it's when you buy something and you say, buy this and the charity gets a percentage, or buy this and the charity gets a certain amount of money. When you enter into that, the commercial co-venture in about 5 or 6 states is required to register as a commercial co-venturer and then provide certain information at the end of the deal. So they have to become a commercial co-venturer, and then at the end of the promotion they have to submit financial reports. And then as part of your charitable solicitation registrations for a number of states, you have to actually provide a list of the commercial co-venture relationships, and some of them actually want copies of the contracts. And it can be really overwhelming to provide this information, but once you get used to it, if you have a system, it's really not that bad. But it's a lot of regulation because consumers get upset that they're buying something because they think a charity is going to benefit, and then it turns out the charity got nothing. And so that's really where it comes out.
And just to go back to the basic definition here, what we're talking about with commercial co-ventures, it's what's on this slide. If you purchase our product, if you go and buy our new app, a certain percentage of the purchase price will go to benefit charity X here in this example, our wonderful client, the Lincoln Center. In any time, the idea is that if you are using that charitable benefit to incentivize a consumer to purchase a product or service, that's usually when we're talking about a commercial co-venture. The statutes do vary in terms of the definitions by state, but that's generally what we're talking about.
Yep, and the statutes call them charitable sales promotions. So the company is called the commercial co-venturer, and the promotion is called a charitable sales promotion. And this is all under the consumer protection statutes. So you'll see those, they're in the same place as you find the disclosures. So the states often require that, like I said, the company registers as a commercial co-venturer, that they post a bond, that they post a surety bond. That's something that's required by, I think, maybe 4 states right now. That you have a written contract, that you have advertising disclosures, and that there's accounting and record keeping. And so you and the commercial co-venturer really have to keep track of the money and make sure that when they say you're going to give you a certain amount that they do.
Yeah, we have a question here.
Yeah, do you see this often? Because sometimes we'll have companies be like, if you like our Facebook page or like our Twitter, does that fall within this realm? Or if they're not purchasing something, is it outside of it?
I've never treated it as such, but I know at one point a while ago Facebook had some issues with charities engaging with companies in that space, but then they changed their rules, so it was kind of okay. But when we did that at TNC, we would ask for money.
And like on this slide, what this alludes to is the fact that in addition to these very kind of specific mechanical type obligations that you're under when you trigger these commercial co-venture statutes, in addition, all 50 states in D.C., all of the state attorneys general have charities bureaus, charities divisions, they call it different things in different states, that very actively regulate this area. And far beyond the specific mechanics of what the charitable solicitation registrations or the CCV statutes require, but general kind of deceptive marketing issues. And they're very concerned anytime that you're using some charitable affiliation to help drive product or service sales of a for-profit company. And there's been a lot of abuse in this area. And as a result, the states, in certain states more active than others, even the New York Attorney General's office, their Charities Bureau, put out some guidelines maybe 2-3 years ago about commercial co-ventures in the breast cancer space. But they're really guidelines that are applicable to all charities that are engaged in any kind of a commercial co-venture, certain kind of best practices that are really important and wise to follow. Things like if you're going to, say that don't say we're going to donate to some percentage. You want to be very specific and hold the company accountable. And the company, if there is, for instance, a cap on the amount that they're going to donate to the charity, that has to be stated publicly as part of the campaign. Things like that, which are kind of basic consumer protection type principles, are things you really have to keep in mind. And you, the nonprofit, have to really actively regulate the for-profit because they're the ones who are engaged in the marketing campaigns. Exactly. Yet there can be risk for you, both legal risk and reputational risk. So it's incumbent on you, both in your contracts and through actual practice, to actively regulate your corporate partners in this area.
Yeah, I actually used to, we initially would have just the BBB Standard 19, which is the Better Business Bureau, has a thing called Standard 19 where they have some disclosure guidance for commercial co-venturers. But then we started just putting the wording in because companies, sometimes they really don't want to say. They don't want to say that they're only guaranteeing $5,000 or they're only guaranteeing $2,000. You have to be really clear with them. If whatever you're going to give us, it has to be very, very transparent. And we have to say that to the consumer because that's the kind of thing that gets you in trouble when it's not clear.
Yeah, question here.
Yeah, so we have an interesting situation because we are hosted by a 501c3, but we're a separate program. and we would be the program that would actually be going after corporations and so forth for sponsorship dollars and potential co-venture opportunities and so forth. Is there a way for us to set up something a little separate from the host institution that is really not doing those types of activities at all, or would they have to restructure the way they're doing their taxes so they fit into some of these categories you were talking about?
Yeah, your question is very specific. Let me try to broaden it a little bit. And really the key answer to your question is who is we in your example? Is we a separate nonprofit tax-exempt entity that's housed within or managed by or affiliated with another tax-exempt entity? Is it a for-profit company?
No, actually it's a program within the 501c3, so it's not a separate legal entity at all.
So in that situation, it is part of that C3 organization, and as long as it remains part of it, all of these obligations, all of these rules, all of the potential taxability of the income, it all applies to that tax-exempt entity. You cannot be kind of a separate entity within that unless you're a separate legal entity. I mean, there is arguably this concept of an unincorporated association, but that usually is not going to apply in a situation like yours. And so unless you want to spin off and form a separate nonprofit corporation and separately apply to the IRS for recognition of tax-exempt status, which you can do, and sometimes organizations do to shield the rest of the organization from all the other burdens and liabilities and other things that may go along with it. But otherwise, your kind of host organization is going to have to deal with all of these things.
And so with the CCVs, what's interesting is we talk about how there's certain obligations on the co-venturer that are imposed by the states. But if the co-venturer doesn't comply, your charitable solicitation registration is at risk because you're not complying with the rules that apply to you as a charity that's allowed to solicit in that state. One of the other pieces of, I think one of the questions was, do you have to do it in the state, was it in the state in which the promotion is being held? If it's online, we've always done it in every state. I know there's questions in that space, but that's generally what I've always advised. If it's brick and mortar and it's really, really just brick and mortar and it doesn't go beyond a state line, I think that's something that you can certainly look at. But usually it's not. With social media and the internet, it's hard to say that it's really brick and mortar. We have a slide here about the BBB Standard 19 that I mentioned. So this is a standard that states that the commercial co-venture should clearly, or the advertising really, clearly disclose how the charity benefits from the sales promotion and ensure that sales promotion is disclosed at the point of solicitation. And that's key. It's when the person's going to make the purchase, they need to see these materials. It's not when they go on the website later to check something out. Sometimes you'll see end caps. Sometimes you'll see it on the packaging itself. But I've run into situations where the marketing deal, they're working things through, and suddenly the company says, oh, we don't have space for that. What do we do? Well, you have to make space for it, or you have to find a space in the store, or you have to maybe put a tag on it. There's ways they can do this because these companies, they generate millions of products. They're pretty good at figuring out how to stick, FDA disclosures on their products. They can figure out how to put a charitable solicitation disclosure on their product too. Because remember, the charity is going to feel the brunt of the pain from the regulators, not the CCB. It's not really going to hurt them very much at all. And tying back to the UBIT piece on this, that if the charity plays, this is a licensing arrangement. So you are licensing your name or logo to a company and receiving royalty income in exchange. So that's non-taxable. But then you go back to the other analyses. Are you going to actively promote this? Because at the end of the day, if somebody buys the product, they're benefiting you. Are you actively promoting it? Are you passively promoting it? Are you providing an advertising service? They're the same. All of these regulatory pieces are there on the state side, but then you have to think through the tax pieces of what kind of activity are you engaging in. And what I find interesting is the CCV is generally when you purchase something and something goes to the charity. There are also structures where a company really wants to put your mark on a product and they give you a flat payment. Some organizations will structure that as a qualified sponsorship. Some will structure that as a flat royalty payment. It really depends on the situation.
And you're talking about for tax purposes, Lakshmi.
For tax purposes, yes.
But it's also important in that first off, it may get you out of a CCV definition in some states,
exactly.
Sure. And secondly, though, it's very some of the state regulators, some of the AG's offices have been very aggressive. If the public believes that the more of the product that they purchase, the more money is going to go to the charity, but it's really just a flat amount, then it is inherently deceptive to imply or suggest or even state, that the more someone purchases, the more that's going to go to the charity. And we've dealt with this situation with some very large, well-known charities involving these flat payments, sometimes payments that have already been made before the promotion even begins. So you need to be really careful in kind of regulating your corporate partner to make sure that they're not making representations in that regard if the additional purchase does not benefit your charity.
Yep. And what I often say is, if you're dealing with a company and you're putting your logo on a product, you should really have the final say in terms of what that looks like, your logo and what the messaging is, because you might do everything right. You have your filings right. You've done everything perfectly. You have your contracts perfectly done. If you are messaging on the product or relating to the product, whether yours or the company's, is misleading, none of that really matters, because you may very well get in trouble from the AG, and then that's a whole other ball of wax.
Yeah, so that's on the state level.
On the state level.
And back on the federal tax side, and just in case you were wondering, there really is no federal regulation of kind of charity and corporate marketing practices at the federal level. The Federal Trade Commission, which otherwise regulates that sort of activity, expressly does not have jurisdiction over bona fide charities. It does have jurisdiction over trade and professional associations, though. But getting back to the tax issues, as Lisa said earlier, quality control is not only important for brand reputation, brand protection, and to make sure you don't run afoul of state AGs and the commercial co-venture statutes, but it's also allowed for federal tax purposes while still maintaining royalty treatment. And then finally, going back, don't fall into the trap on the tax side of saying, well, if we're promoting this promotion, this charitable promotion, and we're encouraging people to buy this product because the more they buy, the more money we get, isn't that related to our exempt purposes? It's not. Just like we said earlier, you look at just the fact you're getting money, or even if you may take all that money and reinvest it in terrific charitable purposes, it doesn't matter. That underlying activity of promoting a for-profit company's product or service is going to generate at least some unrelated business income. Really, the only question is how much versus how much can you fit into a royalty bucket or a corporate sponsorship bucket, or maybe somehow be able to turn it into a related activity.
And then we have a final slide on just how to approach commercial co-venturers. So as we said before, when you're dealing with a company, somebody should be able to say, oh, I think that's a commercial co-venture, and identify that early, because there are waiting periods and registrations and things that you have to do. Plan in advance because of the waiting periods, and sometimes some states actually want to see the ad copy. I think New Jersey, after the fact, you have to send it in. You have to have a written contract, and and yes, in Massachusetts, 2 officers of the charity have to sign the contract. So that was always fun for us when we had to go chase officers around. Sign this agreement. What's it about? Wait, what happened? And then monitor for compliance, because you really want to make sure that the state requirements are being met and that you're being very clear with consumers, because you are in a commercial space.
Yeah, and most of you are familiar with the state in which you're incorporated. Your organization is incorporated, because that state's nonprofit corporation statute is what's going to apply to you guys wherever you're located, and that relates largely to governance matters. But this is one of those areas where all of the state regulators and all of the states in which you are carrying on these sorts of fundraising activities are going to get jurisdiction over your organization if you or your corporate partners are doing active fundraising from consumers in those states. And so it makes you, even though you might otherwise be able to avoid some of these aggressive state charity regulators like in New York and Massachusetts and Pennsylvania and Illinois and Florida, you may not be incorporated there, but if you start advertising or marketing or doing fundraising in those states, then you have to be aware of their Attorney General's offices. We have just a minute or two left. Any final burning questions for our panelists? Seeing none, I want to thank everyone for sitting through a lot of information in a short time. Thank you to our speakers for doing a terrific job, and hope to see you back here next month. Thank you.
Thank you.